Welcome to everyone. Thank you for being with us here on another Tuesday afternoon. We have another full program for you today, so I'm pleased to welcome you. Next slide, please, Kathy. So I'm going to start off as I typically do with a COVID update. Really not that much to report in terms of data and case numbers. Test positivity, it's increased by about 10%, daily average on September 12th, but no real significant changes. We're seeing a decrease in the number of hospitalizations, ICUs, and deaths, all good indicators. So we are trending in the right direction, but as you can see from the chart, we've really flatlined in terms of case numbers. Next slide, please. Again, looking at the picture of New York, light colors are always good. We see a lot of light colors, not a lot of deep orange or red, so good indicators there. A little bit of a spike in Cortland and Allegheny counties, but again, the case numbers are so low that the percentage increases can be a little deceptive. We've already received a question in the chat that I want to address, and that deals with now that the emergency declaration has been allowed to expire, does that mean COVID paid leave goes away? Unfortunately, no. COVID paid leave is statutory with no expiration date. So unless the legislature takes some kind of affirmative action to end COVID paid leave, that is here to stay. All right, now moving on to the interesting topics. We're going to start off with an update on litigation from one of my favorite litigation attorneys in the firm, Dan Pouts. Dan's been on a number of times throughout the years that we've been doing this. So Dan, welcome. Thanks for being here again.
Yeah, thanks, Adam. And not to be critical, but I assume that my invitations have been lost in the mail. I haven't been invited back very often. I suspect it's probably because when litigators like me come on, it's all doom and gloom, and nobody wants to hear that. But interesting topic today, and it's timely. We're talking about inadvertent disclosure and privilege clawback, and that's kind of a broad category. But those of us who have ever been engaged in litigation, it's something we're mindful of, and frankly, as attorneys, it's something we're very mindful of and also very nervous about on a daily basis. The reason that this is coming up now is for those of us who followed the, I guess, complete circus is the only way to say it, of the Alex Jones trial that recently ended. Perhaps the most dramatic moment was when the attorneys for the plaintiffs revealed to Mr. Jones while he was on the stand that Mr. Jones' attorney had inadvertently provided and disclosed an entire copy of Mr. Jones' cell phone data during the course of discovery. Frankly, a complete nightmare situation for attorneys. It's the kind of thing that keeps us up at night. And not surprisingly, with the amount of media attention that the Jones case received, I fielded a number of calls from clients kindly reminding me and suggesting that we probably shouldn't go the same route that Mr. Jones' counsel did. So certainly sage advice. But as a brief backdrop on that, the concept of inadvertently disclosing documents and trying to claw those documents back, that's not a new thing. There's cases going back 50, 60, 70 years that discuss lawyers' inadvertent disclosure of confidential information. The reason that we see it and hear about it a lot more often now is because over the last couple of decades, as most of our records, especially communications, become digital and are stored electronically, just the sheer volume of discovery and relevant documentation that's exchanged between parties in litigation has exploded. Also, the manner in which we review and produce these materials during litigation has also changed. As most of us who have been doing this for any period of time can remember, the days of having dozens and dozens of bankers' boxes and going through them page by page, those days are over. Now, the way we gather and produce and review documents, it's done almost entirely electronically. And as a result of that, and as a result of having significantly more data to review, and often a very limited amount of time to do it, we hear about this inadvertent disclosure much more often these days. But not to fear. Make no mistake, we have multiple layers of protocols in place to prevent this very type of thing from happening. However, God forbid it ever does, there are rules that govern what is supposed to happen. And that I kind of want to briefly touch on that for a moment this afternoon. First, just as a general rule, the New York State Rules of Professional Conduct rule, in the very first part of those, it basically says as attorneys, we must do our best to prevent inadvertent or unauthorized disclosure of confidential information. Full stop. So as counsel, we need to do our best to make sure that we're not sending confidential materials to opposing counsel. However, in recognition of the fact that this does happen, there's Rule 4.4 of the Rules of Professional Conduct that says any lawyer who receives a document that we either know or should reasonably know it was inadvertently disclosed and is confidential, we must notify our adversary immediately. And not to pick on fellow members of the bar, but in the case of Mr. Jones's trial, that was a master class in what not to do when we disclose confidential information. In that case, what we learned was that after Mr. Jones's attorneys were notified about the inadvertent disclosure by his adversary, he still didn't take prompt or necessary action in order to claw that back. And as a result, once the trial came around, that inadvertent disclosure, that became fair game. And ultimately, that was evidence of what we saw, perjury, which I think most reasonable people could agree certainly hurt Mr. Jones's defense. So this begs the question, what steps must we as attorneys take to properly claw back inadvertently disclosed information? First, what we do, certainly here at Bond, what we do and what most counsel do is when the case very in its infancy stages of litigation, we suggest to opposing counsel that we enter into a confidentiality agreement that contains a clawback provision saying, hey, if we inadvertently disclose and we notify you, you have to send it back and vice versa. In fact, in the last few years, we've seen courts strongly encourage this type of agreement to be entered into between parties. And in fact, our commercial division rules in New York State actually provides us with a template of this type of agreement to enter into. So we see that very often, and that's a very strong first layer of protection. But even in the absence of this type of clawback agreement, a lawyer who inadvertently discloses confidential information, they can still claw it back, provided that certain criteria is satisfied and provided that the court is satisfied that such criteria exists. There's a appellate division case that was decided a few years back that lays out the roadmap for what is supposed to happen in this situation. And basically what the case says is, number one, it must first be shown that the document or the information in question was intended to be kept confidential by the client. Oftentimes, that's not a very high hurdle to climb. Usually you can see from the face of a document whether or not it was supposed to be maintained in a confidential way. Secondly, it must be shown that reasonable steps were taken to prevent the inadvertent disclosure. And also, after discovering the inadvertent disclosure, the attorney acted promptly to correct the error. Again, going back to the Alex Jones case, that's something that was not done. After being notified of the inadvertent disclosure, Mr. Jones' attorney, from what we could tell, really took no action, certainly not adequate action. Lastly, assuming those two criteria are met, it must be shown that the party who received the document, the inadvertent disclosure, would not be unduly prejudiced if they're prohibited from using that document. Again, what we've seen, our courts are pretty liberal in if they're satisfied that it's confidential and that it was inadvertently produced. Typically, courts, you're not going to see them find that there's undue prejudice in these situations, not often at least. So, to come full circle, again, not to be complete doom and gloom here, but this is a situation that we hope and we expect that none of us are ever in. But be advised that if we do ever find ourselves in this situation, there are rules in effect and there are protocols that must be followed. And this is an error that can be fixed and a problem that can be overcome. So certainly this is something that if you're in the midst of litigation now, we encourage you to have a dialogue with us about what steps are being taken and what steps should be taken. And it's something that we would encourage you to walk with us together. So thank you again, Adam, for the time. I hope I didn't take too much, and hope to be on here again in the near future.
No, Dan, that was great. Thank you so much. An important topic for those of us involved in litigation. Hopefully not many of you listening are, but you may be at some point. Okay, next up, we have Travis Tallarico. Travis is an attorney in our Rochester office. Travis has been on many times before. I think we're looking at a strange view of the PowerPoint presentation, but I'm sure that'll get fixed in just a second. But Travis, welcome. Travis is here to talk to us about interview question guidance. This is a topic that comes up quite frequently with clients. What questions can I ask during an interview, or what questions should I stay away from? So we've got some updated guidance, and Travis is here to talk to us about that. Welcome, Travis.
Thank you, Adam. Hello, everyone. Happy to be back. It's been a while since I've been on. So good to see everyone virtually again here. So yeah, as Adam mentioned, today I'm going to be going through what Adam also mentioned has been kind of a hot button. I know I personally dealt with this issue for a client very recently, as to what questions can or can't be asked, during the application, but specific to this presentation during the interview process. And so the bulk of this presentation is going to be centered around asking questions about an applicant's involvement in protected categories. And the kind of general rule of thumb here is to be avoiding asking questions in that realm. But we're going to go through and parse out a few examples of some questions that you can and cannot ask, some categories to avoid, and some that are somewhat gray areas. So if we want to move to our first slide. So I believe that most everybody on this call should be aware of the concept of protected categories, but essentially it is somebody's membership in a protected class where an employer is prohibited against discriminating or taking any adverse hiring or employment actions against. So not going to rattle off every single category that's listed on this slide, but everything that's listed here are kind of, some red flags to be thinking about during an interview, and questions that might be asked about somebody's involvement in a protected category. And so particularly in the application and the interview process, the major concern here is that asking questions about somebody's affiliation with a protected category could potentially open the door for allegations of discriminatory hiring practices. So for example, if during the interview you're asking, about somebody's, how they sexually identify themselves, what their nationality background is, where their accent came from. These are all things that could potentially create some red flags if this applicant is subsequently not hired to an allegation of discriminatory hiring. So at the outset, the golden rule of interviews is to never ask a question unless it's directly related to the job that the person is being interviewed for. So I've gone and kind of parsed out some of the various protected categories into two different subcategories. The first is being a classification where, generally speaking, there should not be any questions asked whatsoever about these categories, because generally there's no actual job related applicability towards somebody's affiliation with any of these protected classes. So for example, it's not relevant what somebody's race or nationality they are for their ability to perform a role, nor is their sexual orientation. Asking about involvement in union membership can open the door to liability for allegations that it was adverse action was taken about somebody's stance on union activities. So generally race and color, ancestry and national origin, sex, sexual orientation, gender identity, unions, and credit are all categories that should not be inquired about during an interview at all. Now, getting into, we can call it kind of the gray area here, is some protected categories which may allow for job-related questioning. So what I've done here is there's going to be a few slides addressing each specific category and some examples of questions that you can and cannot ask, and I can provide a little bit of explanation as to how these may apply here. So age, you don't want to ask just simply how old are you. Permissible to ask, are you over the age of 18, for the obvious purpose of verifying their status as an adult. Citizenship, no need to ask specifically if you're a US citizen, but however, you can ask if you're legally authorized to work in the United States. Now, religion, this is one where there can be a little bit of explanation here. So you don't want to outright ask, what religion are you? Do you believe in God? Anything like that. However, you could ask, are there specific times you cannot work, which would encompass, may encompass a religious accommodation or something to that effect. For example, somebody who might be prohibited from working on their Sabbath. Similarly, arrest history, don't ask, have you ever been arrested? However, you may ask if you have any pending arrests, since that may actually impact the ability to, for somebody to start employment. Pregnancy and marital status, kind of similar, outright asking, are you married? Are you pregnant? Do you plan to get pregnant? These are all things that could open the door for allegations of pregnancy discrimination. However, you can ask questions such as, do you have a spouse or a relative that's employed here? Or what days, shifts can you work? Again, if that's, days and shifts that you can work may, be tangentially related to somebody being pregnant or desire to get pregnant. Disability. So disability is a big one to be cautious of. It can seem like a natural interview question to want to understand that right at the outset, but outright asking if a person has a disability or any questions related to that are not appropriate. However, you can ask if an applicant is able to perform the specific job function of the position with or without a reasonable accommodation. Similar for military service, you don't want to ask, are you going to be deployed soon? However, you could ask, you can talk about their military background. For example, how do the skills you use in the military apply to this position? Now, while not necessarily affiliated with protected classes, these are a sampling of questions which generally should be avoided, just to avoid any other allegations of discrimination based upon, somebody's thoughts, beliefs, opinions, etc. So we don't need to necessarily run through all of these here, but a few that are, a few to highlight. What are your political beliefs? There's no reason to be asking that during an interview. Have you ever been a victim of domestic violence? Is certainly one to avoid, particularly concerning the allegation of discrimination due to somebody being a victim of domestic violence, and how much do you weigh, how tall are you, things like that. I know New York State is currently considering adding weight to being a protected class under New York State law, so that's something to be keeping in mind moving forward. And lastly, we have some questions here that I wanted to highlight, which may well be relevant to ask during an interview, because they certainly could be job related, but also could, blur the line of, asking a prohibited question and touching too much on somebody's involvement with a protected category. So obviously, do you speak a foreign language? Could very well be relevant and desirable for somebody's involvement with a position. Do you have a driver's license? Obviously, you want to know if somebody can, have reliable transportation to work, but want to be a little careful asking about that. And then similarly, to highlight, can you work weekends, can be, as we discussed earlier, potentially relevant for somebody's involvement with their religion and their inability to work a weekend due to their religious beliefs. But these are just all some questions to highlight as kind of general considerations, to what you're, to potentially ask or potentially not ask. Now, this was all just a very, very high level overview of, a sampling of questions. Obviously, there are a plethora more that, potentially could be asked, but the main point of highlighting all of this today is for any time an applicant is being interviewed, be conscientious of what you're asking. And even in situations where it might devolve into kind of just a friendly conversation or, trying to reach a common ground with somebody, being cognizant of not asking questions, which may ultimately uncover, information that you're not really supposed to be knowing as an employer at this stage in the game or at all.
Travis, very helpful. Good things to remember. Interview questions and how not to get in trouble. If anyone has any specific questions, feel free to reach out, and Travis or anyone else in our labor department would be happy to help you. All right, next up, we have Lisa Feldman with an update on New York City's Salary Transparency Law. Lisa's been on before to talk about this. Lisa, welcome.
Thank you, Adam. Good afternoon, everyone. So now that the summer is behind us and we're getting closer to the November 1st effective date of the New York City Salary Transparency Law, we thought it would be a great time for a quick refresher. There's nothing that's changed in the law, but I'll bring everyone up to speed. Next slide, please. So who is a covered employer under this law? That covers employers of 4 or more with at least 1 employee in New York City, and the employees are agents thereof. And this 4 employee count under the New York City Human Rights Law is typically a complex calculus. So we would encourage you, if you do have a question about this, to reach out to your favorite bond attorney. Employment agencies of any size are also covered. An employer of 1 or more domestic workers is covered. And although temporary help firms are not covered, the employers who work with them must still comply. Next slide, please. So which postings are covered? So any posting, any job advertisement for a job, promotion, or transfer opportunity that can or will be performed in whole or in part in New York City. And I watched the bill signing live, and the intent here was really to encompass all remote work that could be potentially done within New York City. An advertisement is defined as a written description of an available job, promotion, or transfer that is publicized to a potential pool of applicants, regardless of the medium by which it is disseminated. It includes internal and external postings, postings for full-time, part-time, interns, domestic workers, independent contractors, or any other category of workers protected by the New York City Human Rights Law. It applies to jobs, promotions, and transfer opportunities, as I mentioned, but the good news is that there's no affirmative obligation to create an advertisement by this law. It's only triggered once you create that advertisement. Next slide, please. So what must be included? The minimum and maximum salary the employers in good faith believe at the time of the posting they are willing to pay for the advertised position. We have a definition of good faith, which is what the employer honestly believes at the time they are listing the job that they are willing to pay the successful applicants. The range cannot be open-ended, but if an employer has no flexibility, the minimum and maximum may be identical. The example that the guidance gives is $20 per hour. Advertisements covering multiple jobs, promotions, and transfers can include salary ranges specific to each opportunity. Next slide, please. So how is salary defined? Salary includes the base annual or hourly rate or range of pay, regardless of the frequency of payment, but does not include other forms of compensation or benefits offered in connection with the advertised opportunity, although these can be included if the employer wishes. Some examples include insurance, PTO, pension plans, severance, overtime, bonuses, commissions, etc. Next slide, please. So who may file a complaint or a lawsuit? Only current employees can file a lawsuit against their current employer, which is good news. But members of the public can file a complaint to the city commission, and the commission may also initiate its own investigations based on tips they receive, etc. So there is level of risk here. Next slide, please. So the good news is there is now a right to cure, offer a proof of cure. An employer may show within 30 days of receiving a commission's notice that they have cured the violation. They can submit this electronically or in person. However, if it is accepted, the first civil penalty will be $0, but it will be deemed an admission of liability for all purposes. And the city has given us more information on how to submit the proof of cure, which I have linked to here and will go up on the site tomorrow. And an employer may also seek review of the City Commission's determination that the proof of cure has not been submitted or is rejected within 15 days of receiving this determination. And that information is also available at the website link above. Next slide, please. The potential penalties or enforcement, it's up to $250,000 penalty for the uncured first violation and any subsequent. Monetary damages to affected employees. Employers could have to amend their advertisements and postings, create and update policies, conduct trainings, provide notices of rights to employees or applicants, and other forms of administrative relief. Next slide, please. So just wanted to put the date up here one more time as a quick reminder of when the law is going into effect. So if you have any questions, please feel free to reach out to myself, Seth Gilbertson, or your favorite bond attorney. Thank you.
All right, Lisa, a lot of info there. The slides are going to be available in the presentation, which will be emailed to everybody tomorrow or the day after. There were a number of questions about whether this applies just to New York State or New York City. The answer is New York City alone. New York State is considering its own pay transparency law, but has not passed it yet. Correct, Lisa?
That is correct. It has passed it, although it hasn't been delivered to the governor yet. Although on the New York City note, I would say that you can be a covered employer without your headquarters, let's say, being in New York City, as long as you have that one remote employee in New York City currently. Any advertisement that you do for a job that could potentially be done, at least in part in New York City, is now covered.
Perfect. Thank you very much. Okay, last but not least, we promised you this last time I was on. We didn't have time to get to it, but today we do. So Lou DiLorenzo is going to join us again. You all know Lou. Lou has been on many times before. So Lou, today we're going to talk about defamation in the context of employment. We all think of defamation, the Johnny Depp trial. We heard all about what defamation is, libel, slander, or types of defamation. But how is it relevant to the employment context?
Well, Adam, it's a good question. We do see quite a bit of it in the employment context, usually three areas. The cases that we've defended, we've had a number of cases over the years. They're usually in one of three areas. One is performance issues, a performance evaluation, some kind of a report or a meeting where someone's performance is discussed or assessed. Secondly, references for current or former employees, and the reference is not to the person's liking. And the third way we see it is lawsuits. Last 10 years, we've seen lawsuits where at-will employees will use libel and slander or defamation as a basis for claiming interference with contractual relations, even though they're an at-will employee. And I'll explain that a little bit more. I should say from the beginning, defamation covers both libel and slander. The easy way to keep them straight is slander is say. It's something that's verbal. Libel is something that's in writing. So those are the two forms of defamation that are actionable. The interference with contractual relations, the way that happens, it's a complicated area, but it's something that plaintiffs' lawyers have been very shrewd about trying to circumvent the at-will employment relationship in New York. The lead case is a case the Vladeck firm brought in New York City involving one of the museums. And there were a group of volunteers that a group of volunteers, yes, that badmouth the director of volunteers. They were volunteers unpaid. The director was a paid person in charge of all the volunteers. They spread a number of rumors about her to her boss, including that she was anti-Semitic. She was terminated as a result of that information provided to the supervisor. And she sued for not only defamation, but she also sued with interference with her contractual relation. Of course, the museum's first defense was you don't have a contract, you're employed at will. And the court carved out an exception and said we're going to consider the at-will relationship contractual in this context for the tort of interference with a contractual relationship. But you need to show us that the person has committed some other tort. In this case, it was slander. And so a whole body of law has now arisen where someone says something bad about somebody who's employed at will, it's acted upon, and they claim that they've had a contractual relationship tortiously interfered with. We have a lead case where a CEO of a large hospital terminated an employee and went to the board and discussed the grounds for the termination. The discovery testimony was that she had the authority, without approval from the board, to terminate that employee. The same law firm that won the museum case brought this same action against our client. And we said, no. The supervisor, since the supervisor has the right to terminate the employee, and she's at will, she can't commit a tort of libel and slander with respect to herself. If she lied to herself about what this person did or what kind of an employee they were, it's not contractual interference. It's not libel and slander. The fact that she told the board what she was going to do and why she was going to do it can't be the basis for a tortious interference claim. And the appellate division agreed with us and upheld our standards. So there is an exception where the same person doing the firing is the person that's alleged to have engaged in the libel and slander. But those are the areas that we see it. You know, it's actionable for somebody to do a bad evaluation that other people in the organization see, and someone claims that it's libel and slanderous or defamatory, even though it didn't get published outside the company. Now, the reason that seems crazy to us has been recognized by the law. One of the privileges, I probably should tell you first what the elements are. In order to prove a case of defamation, whether libel or slander, you have to prove that the statement's false. The plaintiff has to prove the statement's false. It's been published to a third party. It's not privileged or authorized, the publication, and it causes damage and harm. There's a small group of types of harm that are considered, you'll hear the reference made to per se defamatory, per se libelous. That means by itself, the comment or the statement is defamatory, and there's no need to prove what we call special damages. But if it's not, doesn't fall into that category, which is, accusing somebody of professional incompetence, they're a lawyer, a doctor, some professional. If you've made a statement that impinges their ethical standards or professional competence, that's per se defamatory. That they are criminals, that they've engaged in sexual misconduct. And we've seen that term used, extended to accusing someone of being a sexual harasser, when in fact they're not a sexual harasser. The last one is infectious diseases. I don't know if that's changed as a result of COVID or not, but the typhoid Mary kind of statements that aren't true about someone and result in them being shunned by people. It doesn't require that showing if you accuse someone of having an infectious disease that they actually don't have. So those are the per se. Otherwise, you've got to plead and prove special damages, which are actual damages. We have a partner who was accused of improper conduct at a bargaining table by a union, one of the teachers' unions, National Teachers Union. And he ended up losing that client based on that accusation, which was not true. And he lost other clients, other school district clients, where this was publicized and republished. And he brought a lawsuit for libel and slander against the union, and he recovered several hundred thousands of dollars. He proved actual damages by bringing in those school districts and saying, yeah, we had to fire this attorney because this allegation had been publicized that he had engaged in improper conduct when it wasn't true. So actual damage is required. So we see we said one of the elements is that you have to act without privilege. One of the big privileges in the employment area is a privilege not created for the employment area, but used in the employment area. And it's the privilege of common interest, people engaged in a common enterprise. employers are. The people that work for the employer are engaged in carrying out the mission of the employer. They're engaged in the common enterprise. There's a case where a non-union company is going through a union campaign, and it's a supermarket, and it has strong suspicions that 3 people have been involved in a theft ring. And these were prominent union promoters during the campaign. They fired all 3 people after an investigation. There was a big rumble within the organization because they didn't tell anybody why they fired them. But there were rampant rumors it was because of their union activity. They hadn't done anything wrong. And to quell those concerns by the rest of the workforce, they responded with meetings saying, we did an investigation and we terminated these people because we believed them to be thieves. Now, the conditional privilege of a common interest comes into play. One of the requirements of that common interest privilege is that we tell people that have a need to know the information. We also have a good faith belief that the information is true, even if it turns out not to be true. Oftentimes, you've heard people say truth is an absolute defense. It is. It's not a conditional privilege. But engaged in a common enterprise or a common interest, that is a privilege. And it disappears if there's malice. That good faith belief, if that's not present and malice is present instead, the conditional belief evaporates, and the only protection you have left then is proving truth. In the case I just mentioned, it would be proving that they actually were thieves, in fact. Now, there's 2 types of malice that can destroy these privileges. One is what we call common law malice. That's just straight spite or ill will. I was solely, if the statement maker was solely driven by ill will, then that's common law malice and the privilege is destroyed. Constitutional malice, on the other hand, is more actual malice. We knew the information was false, or we recklessly disregarded whether it was true or false. So constitutional malice really focuses on our attitude towards the truth or finding the truth out. I don't really care. I recklessly state that somebody's a thief. Don't do an investigation. I act recklessly with a disregard for the truth. That shows a lack of concern for the truth. Common law malice is, I really hate the person and I am solely out to cause them problems. I have ill will towards them. That's the only thing that motivated what I did. So that's more of an attitude towards the person than our actual attitude towards whether something's true or not. Another defense that we run into, Adam, a great deal in the employment setting, is that statements of opinion are not actionable, and that's in New York. You get a wide berth in terms of what are considered opinions. Some of the employment cases, the one that I have, one of the ones that I had, the statements that were made were the plaintiff is diabolical, evil, unstable, and a narcissist. This is the terminated employee. Those were not considered actionable, all statements of opinion. Other appellate division cases have said calling somebody bothersome, a narc, somebody who likes to create issues, again, statements of opinion. Quixotic, self-absorbed, narcissistic, ungrateful, delusional, and a paranoid pompous ass, all considered non-actionable. So when my wife calls me those things, there's really nothing you can do about it. It's a statement of opinion. Using statements of opinion in debates like fiery epithets, rhetoric, hyperbole, again, statements of opinion. So it's a broad spectrum of opinion. And Adam, I probably have skipped over the other 3 questions. Give me one of those questions we talked about you asking.
So I think the one question that's relevant is, what are some best practices for employers?
All right. So best practices, always do a good investigation. Before we start taking action or accusing people of something and either saying it or put it in writing, let's make sure we have a reasonable good faith belief. We don't have to only fire people for being thieves if we're 100% sure and can prove beyond a reasonable doubt they're a thief. That's not the requirement, even under the discrimination laws. As long as we have a reasonable good faith belief they did what we think, we're protected under all those statutes. We want to prepare good documentation. Make sure our documentation is in order. We want to be careful what we say, right? We want to be careful how we say it. It's a lot easier to say somebody misappropriated some material or property of ours, misused it, converted it for their own use, as opposed to accusing them of being an out-and-out thief. So how we say it and to whom we say it. Let's limit those kinds of defamatory remarks to people that have a need to know. On your reference policies, make sure you follow the kind of reference policy our firm recommends that you use. We don't get any pluses in this world for giving references out on employees, bad or good. We really got to worry about our own situation. And when we have a policy of name, rank, and serial number on references, and we depart from it to help a good employee, there's an appellate division case in New York that says you can no longer hide behind that policy. So if I withhold it, and giving a reference is considered a benefit of employment. So if I withhold it against the person that filed a human rights charge against me and refuse to provide a reference on that person, I say, oh, just name, rank, and serial number. And somebody has tape recorded, which there are agencies now doing that for plaintiffs. Somebody's tape recorded a reference I gave on another employee that terminated who didn't file a human rights complaint. I may have a retaliation case for withholding a benefit of employment from somebody because they have filed a previous charge against our company. Be careful about self-publication. Self-publication is a doctrine in the libel law that says even if someone has told you, told the plaintiff something that's defamatory, but they have not told a single other person, if the person they've told it to, the plaintiff, is under some obligation to republish that statement, that can become defamatory. It can fit the requirement that there be publication to a third party, even though it was done by the plaintiff. And in the employment area, this is what the cases look like. I'm firing you because I believe you're a pedophile. I found child pornography on your computer. I think it's from you. Fire the person goes to apply for a job, asks for prior employment, reason for leaving. I was accused of being a pedophile. These are actual cases. The plaintiff sues saying you libeled and slandered me because I'm not a pedophile. They bring into trial an expert who testifies, an HR person, who testifies that this question, reason for leaving your prior employment, if you leave it blank, you're probably going to be not going to be hired. If you lie and say it was for some other reason, you're subject to termination at any time. So the person really has an obligation to disclose that information on an application. There are similar cases on mortgage applications as to why you left previous employment. So there have been times where the allegations were so toxic in terms of being defamatory if they're not true, that I've advised clients, don't give them that reason in the exit interview. Prepare a memo to yourself that you put in your file, your desk drawer. You don't show to anybody else that says, this is why we're firing. But when it comes time to fire the person, don't give them those explicit reasons so they can't republish it. They can only say, I'm not sure. They told me they were going in a different direction or they got rid of me for inappropriate conduct, but they never told me what it was. If we get sued and we have to produce the real reason, we have your memo that's properly time-stamped and dated, and we can prove it happened before the lawsuit. And be careful that even during a trial or a proceeding, any there is a judicial exception, so lawyers like Adam and I can make some outrageous statements during a trial and push everything to the limit. We're encouraged to do that for our clients. But if we stand on the courthouse steps and we give an interview to the 5 o'clock news, there's no protection. The judicial exception no longer applies. So comments we make away from the bargaining table or outside to the newspapers or somewhere else, a good chance we're going to lose any privilege that we have. I'll stop there, Anna.
Lou, very helpful. I have a couple of defamation cases going right now dealing with the employment context, so they are not rare. They
No,
happen. And if anyone has any questions about that, feel free to reach out to Lou or I.
And
All
my
right,
experience with those is people are it's like arguing over the silverware in divorce. I mean, the defamation cases are bitter, like the ones we've seen on TV lately.
Kathy, do you have the last slide? Okay, the last thing I want to highlight before we let you go is our annual workplace seminar. This is live this year, which is wonderful. You can see the dates where our workplace seminar and HR conference are going to be held. These are all day long seminars covering a variety of topics that you can find more about at bsk.com/events. So please take a look. The quality presentations that you get on here will be magnified or expounded on during that all-day seminar. Here is our contact information. It's great to see you all. Thank you for being with us, and we will see you next Tuesday.